Our next case is Hathon versus State of Michigan.
You guys did an outstanding job, I just have to say. They both fit really good.
Good morning. This is a 15-minute mini oral argument on the application, and we have an additional 5 minutes for Miki from the Michigan Association of Counties and Michigan Association of County Treasurers. You have time for rebuttal. We ask that you reserve that and keep track of that yourself, and you may begin when you are ready.
Good morning. May it please the court. Assistant Attorney General Matt Hodge is appearing on behalf of the state of Michigan. I would like to try to reserve 3 minutes of time for rebuttal. We'll see how that goes. But I say that because the questions in briefing here cover quite a bit of material, I understand. So I'm hoping that I can answer any remaining questions the court may have here today. I do believe the state presents the best answers to this difficult problem. They're not perfect. I won't claim that they are, but I think in this situation we're trying to harmonize statutes, court rules, court rulings, and the facts on the ground, in addition to the interests involved. So what exactly am I asking this court to hold here today? First, that Public Act 256 is constitutional, that it's consistent with this court's decision in Raffaelli, and that it controls these claims and all claims like it arising in this context. Second, that if Raffaelli does have some retroactive effect, that this court hold the 2-year statute of repose apply. I want to be clear because I'm not sure it came through in the briefing clearly. In this case, that would mean claims from sales that occurred in 2018 and 2019 would have an opportunity to use 21178T within at least at a minimum 180 days of this court's decision on today's argument. Third, that the court affirm the rights of interest holders other than owners. I think that has gotten lost here. That kind of blends into the next request, which is that this court hold that the current certified class should be decertified. Not only is the definition of the current class inconsistent with the rule's purpose, it is really contrary to this court's holding in Raffaelli. It doesn't respect other interest holders beyond owners, and it creates all these mini trial issues. And for that reason, we really think that class certification here in any context under any definition in this case simply does not work. On the first question, whether PA 256 is retroactive, I think we have 2 questions. Is that what the legislature intended? And then if that is what they intended, is that constitutional? I think on the first question, it's fairly clear that the legislature intended this to occupy the entire field. I think that's the way we've described it. They say in at least 2 places, if a claim is going to be made for the proceeds or damages, I think it goes even more broadly than that, arising from a property tax foreclosure, that this statute is the only way to make it. And 78L, it references 78T, which is the new claim-making process. Within 78T, it says the exact same thing. So if we take the legislature at its word and it's enacting and enabling language that discusses this court's decision and the legislature's intent to give meaning to this court's decision and codify this court's decision, I think that it's clear that that was their intent. Not only that, in practice, the legislature then created a system for people that had claims that were based on foreclosures and sales that happened before this court's decision to make claims, but it sort of put it on the shelf. And I think it left, in a show of ultimate respect to this court, it left to this court the decision on how its own prior ruling would apply. I think it also shows that the legislature, this dovetails with the prior case, the legislature, I think, was somewhat surprised by the result. It's not to say it was wrong, they just did not see it. It was maybe right in front of their eyes, but they did not see it, and nor did anybody else. So rather than decide how that decision should apply fully retroactively, and knowing the consequences of that, they put in this provision that left to this court to decide how that should apply. think that also plays into the tolling question that came up in this case. I think this court does have a role to play in deciding which claims from which period get to take advantage of PA 256. But I don't think that there's any question that was the legislature's intent, that this be the vehicle for any claim that would arise in this context. Second, with regard to that statute of repose, it's been in place since 1999, and I'll be the first to admit that it was not in its current form, but it was based on the only damages claim that the legislature foresaw at that point, which was the potential for a due process claim resulting in a claim for damages. This court heard it in Perfecting Church, in Two Crooked Creek more recently. It's the provision that provided an ability to make a claim for damages after a tax foreclosure. It is the most specific statute of repose or limitation that we could find on this topic. And it really makes sense because this is a self-contained statute. It has its own notice provisions, its own filing of a singular petition. It has its own hearing and objection system, and now it has its own post-sale claim-making procedures.
Counsel, first of all, I thank you for conceding a point, that perhaps having the statute apply to a group that couldn't comply with it would be a difficult argument. You're obviously arguing the 2 years. Obviously, we
Correct.
know that was related to inadequate due process or notice.
Correct.
We've got other arguments for longer periods of time. One of the things I'm wondering is 2 years, we still have to not have a taking, right? So there could be an argument that the statute alone is unconstitutional if it's a taking, another taking, if people can't access the statute. I'm guessing your argument is, well, 2 years is plenty, that gives them access. I mean, what's to say, though, they shouldn't have longer?
Is the question for events that happened, if I just take this case as an example, prior to 2018?
Correct, the actual foreclosure before, filed
Sure.
after, yeah.
So I would say this, we've always, in every area of the law, had some sort of limitation on when a claim could be brought, and I understand that in this instance, we've got the Hart case out there that talks about a 6-year statute of limitations for a taking. I think that's part of the difficult question, one of the factors that we had to weigh here and try to cross-reference. But I think in this instance, again, 78L, I believe, was the more narrow and specific at all times, no matter the language that was encompassed within it at the time, than the Hart decision in the general 6-year. And I say that, again, I keep coming back to this, but this is a self-contained statute. It has its own provisions. The legislature has time and again made mechanisms that are specific to this area, tailored to this area, to try to make this work. And what they anticipated in terms of a potential damages claim, they limited to 2 years. And that was a constitutional claim. So it's hard, I'd be hard pressed to believe that they thought some other constitutional claim should have some other limitation. And I think it also fits in well with the fact that this does impact public budgets. It's local finance that gets hit at the end of the day on this. And in the property tax realm, if you don't like the value that's been assigned to your house that's going to result in a particular tax bill for that year, you have to appeal it that year, and then you're done. So we're pretty familiar with setting up fairly short timelines on things that impact the public fisc, especially locally. And I think that the 2-year limitation was the legislature's intention.
Okay, thank you.
One issue that I don't really think is an issue, but I just want to make clear, I think that this court would benefit the state in confirming that interest holders doesn't just mean owners. And that comes up in this case in part because it's a certified class action that purposely omits other interest holders, lien holders, community banks, construction liens, any other lien that may be on the property or interest in the property. And in fact, I think the statute goes beyond that and it says recorded and unrecorded interests in 78L. That situation that leaves those individuals out in this post-sale process still runs afoul of this court's decision in Raffaelli. If it was the lack of access, if it was the lack of mechanism, which I think is what this court held, to get to those proceeds, and we shut the door on other interest holders beyond just owners, my client is now subject to potentially double or triple damages based on the same finite amount of money from one sale. So I think affirming, which this court, I believe, already did in Raffaelli, the citations to Armstrong, some of the footnotes that talked about the rights of the overage in a mortgage context going back to owners or subsequent lienors. But I think a specific ruling on that would be beneficial. The last piece is related to the class certification here. As we briefed, we think that it's not just problematic, it's not just a difference of opinion, it really runs afoul of that rule's purpose. It is not more efficient. It doesn't provide finality because it does leave out other interest holders beyond owners. Fixing that and bringing them in makes it adversarial within the same case. I don't know how you have anyone have a typical claim when everybody is fighting for the same funds. If you have a piece of property, Blackacre, that has 2 owners and there are 3 liens, what do we do with the ability of one of their rights to opt out? They'd like to go to another court, or they'd like to use 78T to make a claim. Now we have 2 courts adjudicating the same finite amount of funds and making potentially contradictory findings. So I think that it simply just does not work here, and I think that's what the federal courts have started to see in this context in the last few months. There have been decisions since we fully briefed this case, actually, addressing these issues. Admittedly, most of those have focused on equity claims. Those are still going on in some cases because there weren't public sales. And the court said, what are we going to, we're going to have to hold mini trials on the value of all these properties, and that's not workable. Well, the same analogy would apply to a situation where we have to bring in all these competing interest holders, 2 owners and 3 lien holders for one property. And then when we're done with that, we set it to the side and we start over with the next property and its owners. And then we start over again and again. And that's what 78T is built for. It's compulsory. Everyone has to go to one court. It's the same process statewide in every circuit court in every county. It sets a window for everybody to step up and raise their hand, and when that window closes, we know who all the players are, and the court adjudicates priority as among those claimants. It's consistent with this court's ruling in Raffaelli, and I think that it's mandatory.
Counsel, I want to just, I guess, a little bit of a different version of the same question I asked before, but plaintiffs have argued that your proposed 2-year limit would violate our decisions in Bowserman, Mays, and Smith. What's your response to that?
I think at least with regard to Bowserman, the idea that there is no remedy, the court needs to fashion a remedy, we don't have that here. We have the legislature acting quickly and unanimously to try to respect this court's decision and put it into action to give it bones, to put together a process. So we do have a process here, so I think that I can distinguish the cases that way. I think that's the best answer I can give you
Thank
on
you.
that. Unless the court has any more questions, I'll reserve the balance of my time. Thank you.
May it please the court, Ted Seitz again, appearing on behalf of the Michigan Association of Counties and the Michigan Association of County Treasurers. I want to follow up on the state of Michigan's argument as to the class certification issues, especially because there have been significant cases that have come down, decisions from the United States Sixth Circuit Court of Appeals, and even the federal district courts in Michigan over the past few months rejecting class certification of these types of claims for a variety of reasons. One case that we mentioned in our brief is the Fox versus Saginaw County case, where the Sixth Circuit reversed class certification brought against all of the counties in the Eastern District of Michigan, with the exception of Wayne and Oakland. They did so primarily on the basis of Article III standing and jurisdictional issues, but the Sixth Circuit took the extra step, in their opinion, of, in 1 or 2 pages, explaining their doubts on whether these cases can ever be certified for a variety of reasons, including individualized issues, including the 78T exclusive remedy process, individualized issues including the different interest holders in the property. Res judicata is one thing that the Sixth Circuit saw in several cases in front of it on class certification. So the Sixth Circuit has spoken in that case. In a case in Ohio, or dealing with Ohio, Chief Judge Sutton in the Sixth Circuit wrote an opinion also rejecting class certification of similar types of claims brought under Ohio's tax foreclosure statute. In addition, a few weeks ago, the Eastern District of Michigan, in the Hall versus Oakland County case, so Hall back on remand from the Sixth Circuit after the Sixth Circuit issued his decision on the takings piece. The judge in that case, Judge Borman, he rejected class certification of those claims. And for also the reasons in the case before this court, in the Court of Claims, class certification of a class that also spans 78T and those properties foreclosed after this decision in Raffaelli and sold, and those foreclosed before and sold. That creates all sorts of individualized issues. It shows that really ultimately a class action is not a superior way to handle these types of claims. And with that, unless the court has any questions, thank you.
Thank you.
Thank you, and may it please the court, Christopher Kay on behalf of the certified class. And the class respectfully asks this court to either reject the application and maintain the Court of Appeals decision as it is, or else, if it takes the case, to fulsomely address the issue of the constitutionality of Public Act 256's exclusive remedy provision. In any event, Public Act 256, which we've also been talking about as the provisions of 78T, does not interfere and cannot interfere with the pre-Raffaelli claims at issue here. It hasn't been triggered by a decision of this court, and were it to be triggered, the state cannot legislatively extinguish claims, let alone claims against itself, by truncating the statute of limitations, nor can it try to salvage the statute by trying to effectively negotiate a detailed rewrite with this court. As to all of the claims, the state cannot legislatively decertify a class action or preclude a pled class action from being certified. That violates separation of powers. As far as we know, it's never been done in this state, and it would have radical implications for class action jurisprudence. Nor can the state force takings or other civil rights victims into an inadequate quasi-administrative process. That would be a radical retreat from Mays and Bowserman, and in particular, a radical retreat from Raffaelli. Raffaelli recognized a property right in the surplus proceeds, and the state cannot contrive a process to indefinitely hold that property instead of returning it. As to class certification, this is a garden variety class certification in which everyone suffered the same injury. Ex-lien holders do not warrant decertification nor particularized accommodation under Public Act 256. As to retroactivity of Raffaelli, I think that's been handled and discussed at length in the Schaefer argument. But I would just add that the Court of Claims here recognized a claim for a taking before Raffaelli was decided, and it would be irrational that this decision would somehow be overturned by operation of a confirming Supreme Court decision. I want to go back to the issue of Public Act 256. As I discussed earlier, it does not impair the pre-Raffaelli claims in the class because it hasn't been triggered. And even if it were triggered, as counsel for Kent County indicated, it's now been more than 2 years, so the limitations period has run. The government can't extinguish a claim, again, let alone one against itself, by truncating the statute of limitations, and that is a truncation. Raffaelli found a takings claim. The period of limitations set forth in the General Property Tax Act relates to due process considerations, notice considerations in the foreclosure itself, and this is distinct from that process. As to equitable tolling, the state's proposed equitable tolling is so detailed, even, for example, accommodating or purporting to accommodate ex-lien holders and the other interest holders, that really becomes an issue to be hashed out in a legislative committee. And that's not an issue for this court to try to blue pencil the statute to the state's proposed specification. I want to talk also about the class certification issue in terms of separation of powers, because the legislature can't take a pending class action and say that this case cannot be certified. That doesn't just violate separation of powers, but it is a radical departure. Were that the law, then any defendant in a class action would have an incentive to go to the legislature and try to secure a bespoke preclusion of class certification against it. Moreover, PA 256 does not and cannot impair post-PA 256 claims. Again, Raffaelli said that the surplus proceeds are the owner's property. Requiring people to pre-register their claims, in effect, as PA 256 does, runs contrary to this. Remember that PA 256 requires a claimant to provide a notice in the July that happens in between the taking of outright title and the foreclosure and the auction. So before the auction happens and before the surplus proceeds even exist, there needs to be this almost pre-registration that a claimant is telling the government, if you are going to take my property, I am going to try to get it back. That's a violation of procedural due process because it's unreasonable make work. It's a violation of substantive due process because it's not rationally related to the only possible government interest here, which is returning the property to its owner. The idea that the government can hold onto the property for upwards of a year and make people jump through hoops to get it turns Raffaelli on its head. If the government locked you out of your house for a year and said that you had to very specifically comply with these very specific notice and form requirements over the course of that year in order to get back into your house, everyone would understand that that's a property rights violation. Jurisprudentially, that's a lot like the Ingram case that we cite, the Sixth Circuit decision about vehicles that are taken off the street. And the court there was a similar sort of situation where people had to go through this 6 to 8 month obstacle course to try to get their cars back. The Sixth Circuit says you need to give people a hearing within at least 2 weeks. Nor can the state effectively immunize itself from these claims, from these constitutional claims, by making people use an inadequate quasi-administrative process. Bowserman and Mays recognized a cause of action against the state for violation of the state constitution, violation of the Michigan Constitution. Now, Bowserman recognized that the legislature could enact statutory procedures related to this, much as Raffaelli recognized that the legislature could give form to Raffaelli's substance through such statutory enactment. But you can't force people into a Byzantine inadequate claims process without eviscerating those rights. And not just is PA 256 procedurally improper and unconstitutional in that respect, but it clearly violates Raffaelli's dictum, not dicta, that the amount to be returned be no less than the surplus proceeds minus reasonable fees. First of all, this implies interest. As the Proctor case found, PA 256 does not provide for interest. Moreover, PA 256 deducts an extra 5%. Now, the state's defense of that 5% fee is very interesting. They say you need to charge the 5% in order to pay for the new PA 256 process. But you can't set up this obstacle course and then charge people for the privilege of using it. And it also violates the no less requirement because it gives money to lien holders. And I want to return to lien holders in a moment and talk about class certification. But one more thing on PA 256 that's in our briefing and that I think counsel for Kent County discussed a little bit, and that's the supremacy clause. There is always going to be here a federal takings claim. Now, for the state, under the 11th Amendment, we need to bring those claims for vindication of the class's federal takings rights in the Court of Claims. PA 256 cannot extinguish those federal rights. Now, as to lien holders and class certification, because I think those are two sides of the same coin, this is a garden variety class action in which all of the class members suffered the same injury at the hands of the same defendant by virtue of the same conduct. If it shouldn't be certified, it's difficult to see what could be certified. The cases that have denied class certification have been, there was the very unique, and I won't go down the rabbit hole, Article 3 standing issue in the Fox case, and then there was some dicta from the Sixth Circuit about issues that it would like to see the district court consider. The other case, the Ohio case that was alluded to, the Terrify case, had to do with adjudicating fair market value of properties, not surplus proceeds from auctions where there is a defined sum of money. Lien holders, which I take to be the state's primary argument, are a red herring. Raffaelli recognized the lien holder's statutory requirement, or statutory extinguishment, and Raffaelli did not find that that was a taking. That issue wasn't before the court in Raffaelli. But that issue, that argument came up again before the United States Supreme Court in Tyler v. Hennepin County. Tyler recognized that the former presence of statutorily extinguished liens does not impair the underlying owner's claim for surplus proceeds. And Tyler recognized that former lien holders can still collect. We don't know here with our class if any of those debts are timely. Even so, every class is going to have members who owe somebody something. Should every class include every credit card company or medical billing company or collection agency? At most, it's an issue of damages in which the amounts of liens would be simply deducted from damages. And it's plausibly another taking against the state, as was alluded to in the earlier argument. But there's been no such claim of which I'm aware, and now, as to the vast majority of the class, that would be untimely under the one-year notice provision of the Court of Claims Act. Fundamentally, this is a damage case. Takings are damages claims. It's not an in rem proceeding for the allocation of the property. In fact, it's no excuse to hold someone's property that somebody else might have a claim against them. Go back to the Ingram case. Those cars might have had debts on them. They might have had liens against them. The state's one more issue on class certification is that the state's amicus brief, or the Department of Treasury's amicus brief in the Schaefer case, talks about the generally applicable questions to all this tax equity litigation in asking the court to hear the application. Of course, it recognizes that all of these issues, that all of these cases turn on core common issues that predominate over any individualized issues. I want to address briefly something that came up in Schaefer, which is the issue of the potential fiscal impact of these issues and the court's decision. Again, as was discussed in Schaefer, the concerns that have been expressed by and large, if not entirely, come outside of the record. We don't know how much is actually at risk because we don't know how much has been held in reserve, and we don't know how much remains in the delinquent revolving funds. Our best understanding of things is that there is a lot of money in the delinquent revolving funds. I would also add that if you looked at the numbers that were broken out by, I believe it was by counsel for Kent County, talked a great deal about the Western District cases, where there is currently a pending settlement, and there have been objections to the settlement. Candidly, we have, class counsel in Hathon has joined in some of those objections. But there is a pending settlement, and they talked about the substantial amount of money in Oakland County, where there has been a settlement. So that really ends up turning on issues and facts that are not before the court. In any event, this issue was addressed by the Sixth Circuit in the Hall case, and the Sixth Circuit basically said the fact that this could have a big impact, that turns things on its head. A taking cannot be too big to refund. In fact, Raffaelli and Tyler are both explicit that takings law protects us from a situation in which a small number of people have to bear the burden of taxation for the public at large. And here the state's argument and the FGU's argument generally suggests that not just a small number of people, the most distressed people in the community, people who were sick or dying or are now homeless, ought to be bearing that burden. I think that Justice Ginsburg's statement in the Arkansas Game Commission case is very apt here, that the sky is not falling. And I would be happy to answer any questions that the court may have.
I don't see any. Thank you very much.
Thank you.
I was really hoping this would say more like 6 minutes, but we'll work with 3. Good morning again. I have a laundry list of things here, but of course, if the court has concerns, I'd like to start there. What you're concerned about, I'm concerned about. Otherwise, I'll talk as quickly as I can.
So the first thing, just either raise the podium or speak louder.
Well, I think I'll just speak louder because I'm not going to
Great.
figure that out in the next 246. I think one of the problems we have here, and I hope that the court sees it coming through, is we're elevating the class mechanism above really trying to get to the remedy. It really is ill-fitting here, and for all the reasons that have been stated by the courts that have reviewed their concerns with unknown damages claims and that requiring mini trials, we're saying the same thing is going to be true once we get into the litigation about how this gets divvied up and who is owed what. I think the second point here is I never claimed that this was perfect, so I think what we're dealing with primarily in this case from my perspective is an interim period. We know, I hope we know, what happens after PA 256 and that runs its course. We're trying to figure out what do we do with this sort of transition period. And so the idea that equitable tolling, which is this court's authority, is something that belongs with the legislature, I just don't understand that. I think this court clearly has the authority to figure out and apply who gets to make these claims under equitable tolling, including for interest holders other than owners. They have vested property rights. They need to stand side by side and, in fact, probably have priority over owners when it comes to these claims. The idea that the notice of intent requirement is cumbersome or is too difficult to figure out and serves no purpose, I believe we briefed that, but this happens after the foreclosure is final, but before the sale. I think in Nelson it was 20 days, and it was to make a claim, and it was during the proceeding before the circuit court, before there was even a final foreclosure. So it's difficult to see how the Supreme Court passed on that and was fine with it, but this is too cumbersome and too short a length of time. The idea that the state is somehow immunizing itself through this, I want to make clear, we are arguing that payments should be made for a time period from 2018 to 2019. It should be held open. That 180-day window should be given meaning and effect if this court holds that those are compensable. I understand their position. They'd like to move forward in these class actions, but I think I heard that PA 56 first can apply to claims that predated Raffaelli, but then also can apply to existing cases that are pled after Raffaelli, and I don't understand that at all. I think the law clearly applies going forward. Unless the court has any other questions, I think I've made it through. Thank you very much.
Thank you. The case will be submitted, and the court will take a 5-minute recess.